I've heard what you have to say, but technically I'm not supposed to hear from one side without hearing from the
I
other.
understand.
It appears that you may have a legitimate basis for arguing that your mother should not even be involved in this.
Right.
Typically what happens with these, so I can explain it to you, the mortgage company is trying to make sure that they have clear marketable titles so they can turn around and sell it. There is something in the title search that would show your mother has some sort of interest against this property. They want to clear that interest. And I agree with you, just doing that, she shouldn't be responsible for any attorney's fees. But I can't deal with that until the 30th when we deal with their motion for default. So if you don't oppose them clearing your mother's interest in the property and just taking her name out of it, then you can come in on Zoom on the 30th and I'll let you state that when this lawyer is here arguing their position.
Okay.
And then I'll consider it, but it doesn't appear to me that there's any reason she ought to be required to pay any attorney's fees based on what you're telling me. But we're going to let you state those things again on the 30th, okay? I'm sorry you've had to come here today, but I think there's been some confusion about the hearing and the nature of the hearing. But we're not going to require you to come back. We will, the clerk will supply you with a copy of the login for the Zoom hearing, and you can come in on Zoom.
Okay.
As you saw us do today, I think. And when you do that, then you can state your reasons why, and I'll take care of it. Okay.
Right. Thank you.
All right.
Great.
Well, let's go. I'm going to go ahead and allow this guy to come in on Zoom. Have we already got the wrong information? They have sued Ms. Brown and apparently Pete McKnight and Summer Utley on a complaint to quiet title and for declaratory judgment. They basically what they're saying is that we want to clarify who the owner is of the property and so forth. They have filed a motion for default because no answer has been filed. And that motion for default is set to be heard on the 30th of this month. Today, at today's hearing that they sent you notice of is to allow this mortgage company to appear telephonically by Zoom rather than to have to appear in person.
Well, I called on Friday to see if I could also appear via telephonically because my notice says the 30th of March. I was told by the clerk that the hearing for this case was today. I live in Michigan. So I got in a car yesterday and
let me say this. If I allow him to come in telephonically on the 30th, I'm going to allow you to come in telephonically.
I also would like to say that I don't believe my mother should even be a defendant in this case because she has dementia. She's been living in a nursing home for 3 years. I don't know the timeline. Her immediate family was not even aware of this case. That she loaned some money to the other, not even the other two defendants, but Jason.
And your mother's name is Jean Brown?
It's Jean Utley now, but it was Jean Brown 20 years ago when she loaned Jason and Summer Utley $131,000 to buy a home in Ashland City. A promissory note was created at that time, and I guess that created a lien on the title. Jason Utley passed away, but before that, Jason and Summer Utley got a mortgage in 2006. My mother was paid back. No one else in her immediate family, as I said before, that are around knew about this, and it appears that she did not get rid of the promissory note. After Jason Utley passed away, Summer Utley became the sole tenant of the home, and another person, the other defendant, and Summer took out an open-ended home equity loan for $105,000. In looking at the paperwork, it would appear that that loan was defaulted on, and the mortgage company was trying to foreclose on the house and trying to clear the title. That's when the promissory note came up. I don't know exactly when the mortgage company was trying to get hold of my mother. It was after the loan, which was on or around October 13th, 2022. My mother I don't have any records of when Shell Point Mortgage was trying to get hold of her, but it did go to a collections law firm, and they started trying to get hold of her in July of 2024. She wasn't in her home. Her home was sold. She wasn't even living there anymore. There hasn't been anyone around to be able to help this proceed so that the mortgage company could foreclose on the home. By the time I even found out about it on her behalf, it had already gone to collections. I tried to respond to the collections firm. Nobody would respond back to me. I didn't actually even know where else to go. So now they're suing for the legal fees. It appears that they've gotten the title clear. And I don't believe my mother should bear the brunt of these legal fees. The other defendants, I don't have any contact with. I don't think they've even responded to any kind of summonses or serving or anything like that.
All right. Let me explain to you. You have power of attorney for your mother, correct?
Yes, I have a copy of that.
Then the clerk's got, have you got it already? Okay.
You can have a copy.
Right. Thank you. What is it?
Do you need the durable power of attorney copy?
No, just hold on to that.
Okay.
Well, actually, if you want to file that with the clerk so there's no question about your ability to do so, let her make a copy of it and we'll mark
Okay.
that file, okay? What part of Michigan are you from?
Canton. It's in between Ann Arbor and Detroit.
Okay.
So,
Well, be safe going home. I hope,
thank you.
are you out of the snow yet?
It's been very, very cold, and the snow has melted because we had 2 warm days. So going back, Cincinnati is a little questionable, but I think we'll be getting there late enough that it'll be done.
And hopefully we're through the snow part here. So
yeah, I hope you guys are.
All right. Well,
We've got the snow removal equipment.
Well, we will see you on Zoom on the 30th of this month, okay?
How do I get a copy? Okay. All right. Thank you.
Keeps on giving.
You what?
So we have everything done except the title company has a problem with one line in the order that you signed previously. And apparently
Let's slide them in here and I'll hold them in contempt of court for not adhering to my.
exactly.
What line is it there?
They wanted, instead of saying that Aaron had authority to sign the closing documents, I needed to have said in there that the property was divested of husband and vested in Aaron with the authority to sign those documents.
Right.
So I've prepared an order that only fixes that one line, but then I also restated how the proceeds were supposed to be divided just for clarity so there's no confusion.
Well, it's not as complex as I thought it was going to be.
No, it's not. And I've already talked to Mr. Butler about it, but apparently he's not allowed to come back to Cheatham County. So he couldn't be here today.
Has he been banished from the county?
With the
You know, we
GPS.
can't do that anymore.
I know.
Banish him from the realm is the way it used to be called. So. All right. We are concluded. That's it, right? All right. All right, that concludes our business. So we are done for today. We will be back tomorrow morning for Chancery. So I don't know if there's any reason for I need to look at those files. It was just a one case though.
Competition. Trying to fit it.
Okay. I'll just look at that in a minute. All right, thank you. One, is that correct? All right. We'll take her off the docket.
Six, Michael is taking him to one versus the city of Pleasant View at all.
That was a motion to set for trial, and Mr. Leonardo was here this morning with the agreement of the remaining defendant to set it for trial, and we've set it for trial November the 5th, I think, 5th and 6th for a 2-day jury trial.
Six, second in the scene. Behalf of our Department of Transportation versus Juniper 24 location.
Good morning, Mr. Todd.
We have two Venture 24 matters, Your Honor, and we do have this settled. Spoke with Mr. Garner this morning, opposing counsel, and we're just sorting out the final logistics, paperwork and checks, that kind of thing. I think we'll have a final entry within the next
I'm
week.
sure that there's going to be a settlement agreement entered. So, all right, thank you.
Awesome.
Is that the only two that you had on the docket? You have one other.
There's one other, Your Honor, that we're just, again, spoke with opposing counsel that we're going to pass.
That would be 2024 CV 6926, State of Tennessee Department of Transportation versus Felix Bodie.
Yes, Your Honor. Felix and Manford. Yes, Your Honor.
And you're going to pass that one?
We agreement of the parties. We'd like to continue that just to exchange some details, and hopefully we'll have that one sorted out relatively shortly as
All
well.
right. So does that take care of you
I think so, Your Honor.
then? All right. Good to see you. Thank you.
Thank you.
Six, 08, Nikki Henley versus Deborah Lynn.
All right. It's a motion for summary judgment. One of my favorite things in all the world. So let's go ahead and take it up.
Good morning, Your Honor. Greg Patton for the defendant, Deborah Lynn England. This is a motion for summary judgment. The lawsuit is a premise liability case. So the plaintiff, Mitzi Henley, was a weekend guest at the home of defendant Deborah Lynn England. Miss England's home was located here in Cheatham County. Some of the undisputed facts establish that the plaintiff and the defendant knew each other in high school, but later in life became friends through Facebook. They rekindled this friendship, which led to an invitation by the defendant to the plaintiff to be a weekend guest at the defendant's house and attend the defendant's annual Halloween party. So on the Friday before the injury occurred, the Halloween party was on Saturday night. On Friday, the defendant picked the plaintiff up from her home and they drove to the defendant's house. When they arrived at the defendant's house, the primary access to the inside of the defendant's home was a porch on the back of the house that had 3 wooden steps and handrails on each side of these stairs leading up to a deck and then entry into the house. And that was the primary entrance at the defendant's house. Between the time of the plaintiff's arrival on late Friday afternoon and her fall on Saturday night, by her deposition, we count that she used the stairs at least 11 times, both in the day and at night. The plaintiff testified and agreed that the stairs had handrails on each side and that the stairs, the deck, and the handrails were all safe. There's no dangerous or defective condition involved with the defendant's deck. So the Halloween party on Saturday night was to take place in a detached outbuilding on the defendant's property. The plaintiff spent the day on Saturday helping the defendant get ready for the party. There's multiple trips to the shop, back into the house back into the shop. And about 8 o'clock that night, after it was dark, the plaintiff went across the deck, down the stairs, into the outbuilding to attend the Halloween party. Some time later, the plaintiff had to go to the bathroom, and so she went back to the defendant's house. When she got back to the stairs, she went up the stairs. She described there being a porch light on, but the stairs had jack-o'-lanterns, candles, and other Halloween decorations on the back porch. The plaintiff went into the house to use the restroom. When she came back out, the light was off. The porch light was off. It was either a porch light or a string of Edison lights, but they were turned off. For the purposes of this motion, we'll agree that the defendant turned the lights off so that people could see the Halloween decorations displayed on the porch. So the plaintiff comes out of the house and she goes towards the stairs. She knows that the lights are off. She sees the Halloween decorations lit up. She reaches for the handrail and takes a step and misses the stair and falls down the 3 stairs to a concrete landing at the bottom of them. So in this case, the plaintiff has filed a complaint seeking damages based upon premises liability. The complaint filed by the plaintiff alleges that the defendant was negligent in failing to sufficiently illuminate the deck steps to render them safe, thereby creating a defective and unforeseeably dangerous condition. And the issue before the court this morning on this motion for summary judgment, Your Honor, is did the defendant have a duty to the plaintiff? So the law is that the owner of property has a duty to remove of or warn against latent or hidden dangerous conditions on the premises of which the owner was aware of or should have been aware through the exercise of reasonable diligence. The case law, Eaton versus McLean and Miller versus Mount Laurel Chalets that we cited in our brief also include that a duty of an owner does not include warning against conditions where there is no unreasonable risk anticipated, and there is no duty to warn against conditions that are open and obvious. So in Eaton, that was a 1994 Tennessee Supreme Court decision. It was one of the first step in the dark cases. In Eaton, we had a plaintiff who was visiting her daughter and son-in-law. She was familiar with the house. She was a weekend guest. She was in her bedroom upstairs. In the middle of the night, she needed to go to the bathroom. She goes down to the hallway. Instead of going in, opening the bathroom door, she opens the basement door, steps in the dark, and falls down the basement steps. In Eaton, the court says that the duty to warn of latent or hidden dangers does not arise if the danger is open and obvious. And because stairs descending from a hallway to a basement are a common feature of many homes, they are not inherently dangerous. So we've also cited the case, the Miller case, which is a 2002 Court of Appeals opinion. And in the Miller case, that involved a plaintiff who had rented a 3-level chalet with a basement that was accessible by stairs from the 2nd level. Again, it's a step in the dark going to the bathroom case in the middle of the night. In Miller, the plaintiff got up to go to the bathroom. opened the wrong door, took a step in the dark, and fell down the basement steps. In Miller, the plaintiff had acknowledged having been to the basement at least 5 occasions prior to her fall. And the court held that the defendants could not have reasonably foreseen this conduct, especially with respect to a lady who had used the bathroom at night on a number of occasions during the week and had visited the basement on at least 5 occasions prior to her fall. Your Honor, those 2 cases are on point with the case before the court this morning. The case before the court this morning, in this case, we have a plaintiff who was a weekend guest. She had not been to the defendant's house before this, but she arrived on Friday, had the fall sometime after 8:00 p.m. on Saturday. Here we have a plaintiff who had, by count through her deposition, been up and down these stairs, both in the daytime and at nighttime, 11 times, both the day before and on the day of the incident. The plaintiff admits that the stairs and the handrails were safe. There was nothing dangerous or defective about the stairs. What we're dealing with here is just darkness. At 8:00, when she went to the party at the detached outbuilding, it was dark outside. She later left the party, went back up the stairs. It's dark outside again, goes in the house, uses the bathroom. And when she comes out, she acknowledges that she knew the porch light was off. She looked at the Halloween decorations, and she just simply missed a stair, descending the stairs to go back to the party. So, Your Honor, just like the courts in these other step-in-the-dark cases of Eaton and Miller, we'd ask the court to find that the defendant did not owe a duty to the plaintiff in this case because darkness was open and obvious, and there was no other defective condition on the premises that caused her injury. Thank you.
Thank you.
Morning, Your Honor. Michael Bradford for the plaintiff. As Your Honor well knows, a negligence case involves several distinct elements that must be proven by the plaintiff. Duty is one of those elements. As I'm sure Your Honor also is very familiar with, defendants like to latch on the issue of duty for summary judgment purposes because that's an issue of law. Plaintiff admits in this case that Your Honor, duty is established. As pointed out by defense counsel, this were 2 people that knew each other years ago in high school. They had not maintained a friendship. They had recently rekindled a friendship through Facebook. And this particular weekend was the plaintiff's first occasion to be at the defendant's house. She was there for a Halloween party that was on a Saturday evening. She got there. She was picked up by the plaintiff on the Friday evening. She had been there throughout that day on the day of the party. When the party first guests arrived, the plaintiff was still in the house. She left the house, went out to the party around 8 p.m. She had to go down to the steps where she later fell and go out to the party, but the porch light was on. After socializing at the party for a while, she had to go back into the house to use the bathroom. That time, according to her, the porch light was on. When she came back out of the bathroom to go back out to the party, according to the plaintiff, the porch light had been turned off. But she didn't know where the light switch was. She used the porch railing to hold on as she went out the back door, approached the stairs, and traversed down the stairs. And going down the stairs, she got to where the porch rail ended. She was reaching for the stair rail, and she missed the stair at the turn, and she fell. And as she was lying there, then told her she had turned off the porch light so that people could see the jack-o'-lanterns and the other decorations. And I have provided Your Honor with the file and a copy of a photograph that was exhibited at that deposition. Actually, it may have been exhibited at the defendant's deposition. To prevail on a motion for summary judgment, the moving party has to show both that there's no genuine issue of material fact and that the moving party is entitled to judgment as a matter of law. If the material facts have to be weighed, then they're not entitled to summary judgment. Plaintiff submits defendant's not entitled to summary judgment in this case because reasonable minds can differ as to whether or not the defendant is liable to the plaintiff. The defendants recognize that, I believe they do in the brief, that the defendants have a duty as a property owner. They have a duty to exercise reasonable care with respect to persons lawfully on their premises. And the defendant characterizes the case as a step in the dark case, relying on the courses, cases discussed with counsel of Miller and Eaton. In plaintiff's reply, Your Honor, I've cited the court to two more recent cases of Shacklet and Pope. And both those cases involved dark situations. In Pope, the plaintiff was at a house where she was not familiar. As she was leaving, she tripped over a retaining wall. And in Shacklet case, as a person who had been working during the parties, my recollection, as help for the party, and as she was leaving, then she fell also going out the back step. The court in those two cases distinguished Eaton and Miller. First, like for example, in Eaton, there was no reason for the plaintiff to expect entry into the part of the house where the fall occurred. In this case, as defense counsel said, that was the main entrance in and out of the house. That was how people were expected to go in and out of the party. Also in Eaton, that was someone who was thoroughly familiar with the house. This weekend was my client's first time there. She had been there in and out sometime before this fall, but as she said, the lights were always on. This was the first time the lights were off. She didn't know where the light switch was. Similarly, in Miller, in that case, there was a plaintiff who opened the wrong door, fell into the basement while trying to go to the basement in the dark. Her reason for what she did was because she didn't want to wake the family by turning on the lights. In this case, my client didn't know where the light switch was, and she was trying to get back out to the party. So we submit, Your Honor, that there are distinguishing factors in this case, that my client was expected to use those steps. That was the way in and out. She was not familiar with them in the dark. She didn't know where the light switch was. And the defendant told her before she left the scene there, before taking away in the ambulance, that she had turned them off so that she could see, so that the decorations would stand out better. And the plaintiff submits that that is a pretty insignificant reason to subject the plaintiff and other party goers to the potential risk presented by the dark lights. So we submit that there are disputed issues of genuine fact in this case, genuine issues of material fact, and we request that the court deny the motion for summary judgment. Thank you, Your Honor.
Ben?
Thank you, Your Honor. Counsel didn't really point out to the court any disputed material fact. You know, we filed our statement of undisputed material fact. Counsel for the plaintiff responded to it. Almost all of it was admitted. Those parts that were disputed, we waived that and agreed, okay, we'll agree with whatever you say the facts are. And that is the balance of the statement of undisputed facts before the court. There are no disputed facts in the case. He didn't say anything in his argument that was a disputed fact. It's just they attempt to rely upon these two cases of Pope and Shacklet to try to create a disputed fact. And those cases really are not analogous to the case that's before the court. In the Pope case, yes, it dealt with darkness, but it dealt with the darkness masking a 1.5 foot retaining wall that the plaintiff fell over during the plaintiff's first and only visit to the property of the defendant. So there's a totally different analysis in Pope, because then it became an analysis of foreseeability, because you had this other independent, dangerous or latent condition, the 1.5 foot tall retaining wall that the plaintiff tripped over. In Shacklet, again, there was another additional instrumentality that came into play that caused the plaintiff's injury. It wasn't just darkness, it was a broken handrail on the stairs that the plaintiff was descending at the time the plaintiff fell in Shacklet. So those cases, although there's an attempt to use those to say, that there is a disputed material fact, they don't overturn Eaton, which is the 94 Tennessee Supreme Court decision. So the holding in Eaton is still intact and should apply to the case at bar. So again, Your Honor, we'd ask for summary judgment in favor of the defendant.
All right, I'm required to issue a written finding of facts and conclusions of law and ruling on your motion, so I'll have to take it under advisement. That was why I said I really love these things. So I will get you an answer as quickly as I can.
Thank you.
I'm gonna hold on to this thought.
Your Honor, I have nothing further to report. Commissioner, I'll-
You may.
Okay, for 6919, Michael Arnett.
Morning, Your Honor. Taylor Pruitt for the UM period. That's my motion.
All right. All right, I'll hear you an argument.
Morning, Your Honor. Taylor Pruitt. I believe this is my first time in your courtroom, so it's very nice to meet you. This is a single vehicle, motor vehicle accident in which the plaintiff alleges a John Doe made him swerve off the road. Plaintiff was on the job at the time, so he's tapped 2 insurance policies belonging to his employer. The first is a workers' comp policy. He was paid $222,099.62 in workers' comp benefits. In this case, he's also seeking compensation from his employer's UM policy. As is common in UM policies, there is an offset provision which reduces the amounts payable by UM by any amounts paid or payable by workers' compensation. And so what we're asking the court to do is issue a very, very simple order. And it could even be 1 or 2 sentences long. And what that order would do is resolve a dispute that's been going on again with the parties since the inception of the case. And it's important that that dispute be resolved now, because Mr. Fisher and I have a very important job of explaining to our clients the costs and benefits of going to trial. And every plaintiff wants to know, if we win, how much money is going to go into my pocket? Just like every defendant wants to know, if we lose, how much money is coming out of my pocket? And I don't think either of our clients want to spend the time and expense of going to trial only to be unpleasantly surprised at a post-trial hearing for remittitor. Because if, for example, the jury awards $400,000 in damages, it seems to me, based on the case law in our motion, that the UM carrier would only pay a maximum of $178,000. That's a big difference. And if the plaintiff is under the impression that he might collect the full $400,000, then one of us is wrong in the amount of hundreds of thousands of dollars. So it would be great if we could figure out this issue right now. And we may not know the ultimate amount of that offset following a trial, but at a minimum, we know that the workers' compensation carrier has paid $222,099.62. So at a minimum, the settled case law says that amount reduces the legal liability of the UM carrier. And so any amount that we would dispute at a post-trial hearing would only increase the amount of that offset.
Let me ask you a question. It is the established law, if I recall correctly, that a workers' comp would have a subrogation interest against any recovery from a third party.
That's right.
So if the workers' comp is paid $222,000, then that is the amount of their claim. But what you're saying is that it reduces the liability of the uninsured motorist carrier. And how would that be the case? Is it the same company as the workers' comp?
So in this particular case, there would be no subrogation by workers' comp because it's a John Doe tortfeasor. And the Tennessee law says that workers' comp can't subrogate against a UM policy.
Okay.
So that issue is not present.
Your file. That's the reason I'm asking the question.
That's totally fine. The reason probably this is my first time in your courtroom is because I did workers' comp for 7 years. I know Mr. Fisher did the same thing. And so I'm just now getting into the liability side of things, but the subrogation from the work comp side of things is not going to be an issue in this case. Now, to the extent that the plaintiff has
Let me interrupt you.
Yeah,
again.
go ahead.
How then does the settlement by workers' compensation and the payment by them, how, in your estimation, is that going to reduce the liability of the uninsured motorist carrier?
It's a great question. So the main dispute in this case has been, how do we subtract the amount that workers' compensation is paid, which we know what that amount is, the $222,000. Where does that subtract from? Does it subtract from the jury award, or does it subtract from the insurance carrier's policy limit? And what the law says, and we've cited it in our motion, is it depends on whether it's the lesser of the two. So it depends on whether the jury award
You
is
started to say the lesser of two evils, didn't you?
the lesser of the two between, the jury verdict and the policy limit. And that's what's referred to as the UM carrier's limits of legal liability. Because if the jury verdict is $400,000 with $1 million policy, they would be on the hook for $400,000. If the policy limit's $300,000, well, they're not going to pay more than $300,000 because all of this arises out of contract. So in this case, if we assume that the policy limit is $1 million and the plaintiff recovers $400,000, then UM carrier's technically on the hook for $400,000, but when you apply the offset of $222,099.62, it's only, $178,000 roughly. And so it's important for us to figure this out, because when we advise our clients, hey, what's the likely result? If we disagree as to that, I think we want to figure that out now. And so the proposal for the order would be very simple. Progressive is entitled to an offset in the amount of $222,099.62 plus any amounts determined to be paid or payable by workers' compensation established at a post-trial hearing. And then that takes care of all the issues that Mr. Fisher cited in his response about, well, we don't ultimately know what might have been payable in future medicals. That doesn't matter. We know what workers' compensation has paid to date. The only thing that could happen at a post-trial hearing is that amount grows by any argument that we have. And so I think setting that minimum is what we're asking your honor to do today, just to say, yes, Progressive has an offset. It applies to the limits of their legal liability, and it's in the amount currently of $222,099.62.
Okay. Well, let me hear from Mr. Fisher.
Morning, Your Honor. Michael Fisher for the plaintiff. Our big issue with this is it's way too early for the court to make any determination on this case because there are so many unknowns in this case as what damages will be awarded, if any damages will be awarded, what category of damages will be awarded on the jury verdict form, because each one will be itemized, medical expenses past, future, all that. There's not a single Tennessee case where a court has made a ruling that the defense is asking for in this case. All of the cases cited by the defense and that are published and available to the parties are all post-trial motions and orders on post-trial motions. I think they're just trying to put the cart before the horse in this one, Your Honor, and I think they're essentially seeking an advisory opinion in this matter, because again, there's not been a single medical proof deposition. The only thing we've done is the lay proof of the plaintiff in this case. So we are in the process of getting medical proof set and getting the case set for trial, but at this point, we're before a verdict, so we don't know what's being reduced. We don't know, they've cited a SD, I think it's SD2 form now from the Department of Labor, which breaks down total amount paid under workers' comp, but we haven't been able to verify that's correct. I didn't represent him in the workers' comp claim. He handled that, my client handled that himself. So I haven't had a chance to even verify all those numbers are true and accurate. So I just believe, again, that this motion is premature. There's no problem. I think both of us can advise our clients on our interpretation of the policy language based on other cases that have had similar policy language interpreted by the courts. So I don't really see that being an issue where we need a court ruling at this point, Your Honor.
Let me say this is my first day of this term of court, so I have not read your file, so I'm going to take a recess and read through the pleadings and then come back, and I'll give you both an opportunity if you want to add anything to your argument after I've familiarized myself a little bit more. All right, thank you for letting me take a recess and bear with me while I look through your file. Essentially, it appears to me at least, essentially, and that the defendant in the case is arguing that I should put an order down that says this is the law and this is what will happen. And the plaintiff is arguing that that's an advisory position. I don't think that it's necessary for me to say that the law of the state of Tennessee is this. That's an acknowledgement of what the statutes provide and what the case law provides. I think that I have to agree with the plaintiff's position that there are many uncertainties about the application of the workers' compensation as an offset, that prior to a jury verdict in which the jury verdict would establish certain damages, and while you could say, well, they're entitled to this offset and it'll be determined based on what the jury does, there's really no reason to do that other than to provide, the defendant with some sort of guidance that would help them in settlement negotiations. And I don't believe that it's the function of the court to act in that way. I do agree that it would be in the form of an advisory opinion. And for that reason, I'm going to deny your motion, but allow you to certainly resume that motion once the jury has reached a verdict in this case. And that way you're able to see what the terms and the various components of the jury's verdict are. And then you'll know how to apply the workers' compensation offset. Clearly, the workers' compensation offset applies, but it's just a question of what does it apply to? And I think it's important that, as the plaintiff pointed out, that workers' compensation for lost wages is only 2/3 of the actual wage. It's not the actual wage itself. And the plaintiff is entitled to recover from the uninsured motorist or the person who caused the accident the full value of his lost wages. And I think that's an example of what we could get into if we start saying this is how it's going to apply. So I just think it's premature, and I am going to deny your motion. I understand your logic behind it, why you would want to do it, but I think at this point in time, I'm going to have to deny your motion as being prematurely filed. Thank you. And Mr. Fisher, if you'll draw an order for that.
That's all I have. Maybe excuse your
You
honor.
may be excused. Thank you.
Yes, Your Honor. Thank you.
Right. Oh, yes. I got the case. I have the file. Let's put it on. Yes.
1997 doesn't finish at all, or if it's not the case, you don't file.
Good morning.
Good morning, Your Honor.
Lindsay Racing.
Right.
Yep, Noel
This is
Bagwell
a-
for the plaintiff.
Plaintiff's second motion to compel discovery and to enforce the court's prior order.
Yes, Your Honor.
All right.
May it please the court, Noel Bagwell for the plaintiffs, Douglas and Cynthia Simmons. Defendants are trying to make this more complex than it is. I really believe this comes down to three things. First of all, the defendants have not complied with this court's order from last year. We were here almost exactly a year ago in March. And then the written order came down from the court about a month later, compelling defendants to comply with their discovery obligations within 20 days. And they have not done that. There's been a lot of misdirection and obfuscation also in the response.
to our motion, this instant motion filed by defendant's counsel. They also have not produced the full copy of the insurance policy that's relevant in this matter. That is,
Is the insurance policy relevant?
it's described in the contract. It's listed in the contract. We're not looking for deep pockets here. They stated that they were properly insured, and this is a fraudulent misrepresentation case, among other things. So we just don't believe that that's true. We don't believe that it's true because as the exclusions page sets forth, essentially everything that defendant Corey was doing, that Sunday's Pool and Spa was doing, seems to be not covered by her insurance.
If I may, we do want to expect the discussions about policies coverage, because this came up only in the context of Rule 408 confidential settlement discussions. Coverage case, their fraud claims do not touch on insurance coverage. I'll say my piece when it's my turn, but I do want to lodge this objection.
I note your objection. I think any settlement discussions would obviously be inadmissible as part of any kind of proceeding, even an argument on a motion, because of the fact that the rules clearly specify that it is not admissible to discuss settlement negotiations in this case. So.
Your Honor, respectfully, they've waived that. They have produced text messages with one of their other customers, Taryn Chapin, in which Allison Corey mentions that my clients are supposedly, or accuses my client supposedly of just litigating to go after her insurance policy in the amount of hundreds of thousands of dollars. So she's already opened the door to that, to discovery of that. And respectfully, I think that there's a sword and shield problem here, where they can't both use this as a sword to lowball settlement negotiations and then hide behind Thomas v. Oldfield as a shield, saying, no, you can't see the entire policy. And whenever it's directly on point to our
argument is that you're attempting to introduce settlement negotiations, which are inadmissible by rule. And you're saying they waived the settlement negotiations rule?
Yes, I'm saying that they've already brought this up, or that the mention of the insurance policy came in outside of the settlement negotiations because of the discussions that she'd had with another customer in messages produced by them eventually. But they basically have opened the door on this insurance policy. It absolutely is discoverable. Whether or not it's admissible would be a separate issue, and we admit that. But that's for a different day. This policy is absolutely discoverable, and also they're obstructing access to BLC, the Board for Licensing Contractors records. In their own response, they say that the BLC's records are, public records that we could just get access to. That's extremely misleading and disingenuous, because they know, as the BLC says on its own website, that there are certain records that are confidential, and that you must obtain a stipulated protective order or some other protective order which would protect their client in order to obtain those records. But they won't sign a standard stipulated protective order that would benefit their own client, because they want to obstruct access to these records. So, Your Honor, when we filed this, I wish that were all, really. I wish that were all, but when we filed this second motion to compel on February 3rd, we believed that we were dealing with just these three issues, with standard, it shouldn't be standard, but discovery obstruction. They had produced initially scrolling videos where their client was just scrolling through iMessage on her phone of text messages, not the actual messages, certainly not in a native format with metadata and all the other e-discovery ESI data that would go along with just the standard messages. They didn't produce that. They produced an MP4 video of just scrolling through it. I can't Bates number that. It's hard to reference that. You don't want to have to dig through all of that or have it presented here at trial as an exhibit. It's not reasonably usable. It's not a reasonably usable format. When we objected to that, months later, they finally produced PDF copies, but the PDF copies were white box redacted. They were essentially mutilated, and all of the image attachments were missing. The image attachments were not produced until 6 days after we filed this instant motion. And then last week, the posture of this case shifted again. After we received their response to our Rule 37 motion, in which they said that they performed a good faith, diligent efforts search, we received a voluntary disclosure from a third party, Biodesign, the manufacturer, the exclusive manufacturer of the pool materials used in this project. And their production revealed that defendant's conduct here is not just run-of-the-mill foot dragging, delay, deny, defend tactics or obstruction, which on their own would be cause enough for this motion, but it's the deliberate, calculated alteration of evidence. It's spoliation by curation. And in their response brief, again, defendants boldly claim they conducted a good faith search. They admit they withheld what they deemed unresponsive text messages without logging them. There's no privilege log, apparently considering them irrelevant personal banter or something. I don't know. We don't know because there's no privilege log. We don't know why they white box redacted their PDF. And when you look at what they're treating as unresponsive, I would direct the court's attention to exhibits G and H attached to our reply to their response. And after months of delay, defendants gave us this PDF showing defendant Corey's text thread with Biodesign, specifically with Francis Leo Grand, who's kind of the big man over there, the boss man. The buck stops with Francis Leo Grand. Their PDF shows the conversation starting. The PDF that was produced by defendants shows the conversation starting on May 11th of 2024, and they're discussing the leak in plaintiff's pool that they're responsible for and that they were aware of, but refused to cure. But the native text messages that were provided, or rather the screenshots of text messages provided directly to us by Biodesign, prove that this exact same conversation depicted in the messages that they produced actually began 3 months earlier. February 12th of 2024, or began sooner, but the messages we got from Biodesign, they start as early as February. The messages that were produced in response to our discovery request don't start until May, 3 months later. What did defendants intentionally withhold? Well, they withheld Biodesign telling Ms. Corey that she had not purchased materials in over a year and a half. So there's no way that her statements that she was going to order materials for my client's pool could be true, because she hadn't ordered any new materials in over 18 months. They withheld Biodesign telling her that she was prohibited from buying materials until she was retrained because of her difficult pool builds and all the issues that she'd had with the customers and all the problems that she had caused for Biodesign. This is a fraud case. It's not just a breach of contract case. They deliberately severed, or Ms. Corey didn't produce to her attorney, and her attorney relied on what was just handed to her, whatever the case may be, the first 3 months of a continuous business text thread that hides smoking gun admissions that they lacked the materials and the training to build my client's pool. This is the very heart of the fraud case. They handed us first video of plaintiff scrolling through iMessage and then a mutilated PDF. They hid the redactions and then produced them without the attachment images and called it compliance. Under the Supreme Court's mandate in Tatham v. Bridgestone, this is sanctionable spoliation. Because of this deceit, our requested remedy has changed this morning. We're no longer asking the court just to order defendants to, reproduce their ESI. Ordering them to reproduce these records would be like asking the fox to do a second inventory of the hen house. They've forfeited the presumption of good faith. And Your Honor, I remember your admonition the last time we were up here for lawyers to not be making accusations of bad faith and things like that without evidence. And I have thought about that long and hard before filing this motion and coming up here and making these arguments. I would not be saying these things if we didn't have absolute proof. The only way to ensure the completeness and integrity of the evidentiary record, unfortunately, is to take the keys out of defendants' hands. We respectfully request that this court exercise its authority under Rule 37 and 53 to appoint a special master or to order the use of an independent forensic ESI vendor to image defendant's devices, her computer, her phone, wherever these ESI records may be stored, and extract the complete uncurated record with 100% of the cost borne by defendants as a sanction for their spoliation. Defendants spend pages in their response complaining about Ice Storm Fern. We were all impacted by the storm, but Ice Storm Fern did not cause defendants to permanently doctor text messages months before the storm hit. It did not cause them to withhold their insurance policy for over a year. It did not cause them to unilaterally block a third-party subpoena to the state licensing board. They boast that they finally produced the missing text messages on February 10th, 6 days after we filed the motion, apparently arguing that this moots our request for sanctions, but it does not. Under the rules, the court shall, as you pointed out in your prior ruling when we were up here before, shall award attorney's fees against the party whose conduct necessitated this motion. And this motion is necessary because of their conduct, unless their actions were substantially justified. And we argue that they were not. They stonewalled us for months, forcing my clients to incur the expense of drafting and filing this motion, only to hastily produce the image attachments a week later. There's no substantial justification for forcing us to seek court intervention just to get them to comply with your order, with what this court has already ordered them to do. I don't want to press the insurance policy issue too much, but the Thomas v. Oldfield case that's been cited here was a case where essentially the plaintiffs were looking for an insurance policy, fishing for deep pockets. And that is not what's happening here. All we're saying is that the contract between the defendants and my clients stated that she was properly licensed and insured. It explicitly states that. It's section B on the front page. It's right there. And my clients relied on that misstatement that she was properly insured for her work in entering into the contract with her. They would not have entered frivolously into a contract with a contractor who was not properly bonded and insured, not properly licensed. They wouldn't have done so knowingly. So they reasonably relied on those statements. So absolutely her insurance policy is discoverable because it's relevant to the fraudulent misrepresentation that she made. It's not just a fishing expedition to try to find deep pockets. And also the BLC requires an order in order to get the other records and that are on file with them that are also relevant to the case as outlined in both our motion and our reply to their response. I feel like I've gone on maybe a little too long, so I'll just conclude by saying defendant's cross motion to compel mediation also is premature and, in my opinion, respectfully, absurd. We can't be forced into a blindfolded mediation while defendants actively obstruct access to VLC bond records, refuse to give us the complete evidentiary record. We need the uncurated evidence that goes even further to prove our clients' fraud claims. As we've seen from this single, small, voluntary production from Biodesign, they're not giving us the whole picture, and we believe that there are yet more records with Brian Wallace, with Narcissus Palomino, and others that they're still withholding. We ask the court to grant our motion to enter an order for relief as requested, and also to order an independent forensic extraction of defendant's expense, to order the BLC protective order, to compel the insurance policy, to deny mediation at this time, and to award mandatory expenses. To be clear, we're eager to settle this case. We want this resolved. We want to go to mediation. We don't want to do it kneecapped and blindfolded. Thank you, Your Honor.
Counsel?
Thank you, Your Honor.
Good morning, Your Honor, again. Lindsay Ray, and this is Mary Moss here with me today representing Sunday's Pool and Spa, and Ms. Allison Corey, the defendants to that matter. And if you'll indulge me a moment, I do want to give a little bit of the background for context to help explain where we are today. Now, it was Simmons were a client of defendants, but first Ms. Corey did consider the Simmons friends. In April 2023 is when this contract was signed for Sundays to build this custom pool for the Simmons for an amount of about $130,000. The contract was then amended November 2023 to add a deck for just over $40,000. There are no complaints that I'm aware of about the deck, so really it's the $130,000 pool that is at issue. That pool and patio were near completed, starting late 2023, early 2024. And as Mr. Bagwell did reference, there was a surface level leak that was detected in or around April 2024 while construction was coming to a close. My client did make efforts to correct the leak and try to finalize the pool. The Simmons did, though, become unresponsive around May of 2024, not letting her come with the expert to look at the leak, which is their prerogative, it's their property. And then by June of 2024, they had canceled the contract. I will note that there was a final, I believe it's $26,300 on that pool contract that was paid. So it's about $105,000 that was paid toward that pool, taking away the amount for the patio. So the Simmons filed their complaint in September 2024, and they did bring up mediation shortly thereafter. As Mr. Bagwell referenced, the complaint is largely one for breach of contract, and there are some other claims that include fraudulent, negligent misrepresentation, among others. Now, defendants responded in October 2024, of course, denying these claims. We brought some counterclaims, and we'll get into that at a later time. Plaintiffs had issued their initial discovery requests contemporaneously with their complaint, so we issued our written responses and objections. It was October 31st of 2024. Plaintiffs' counsel then called my colleague, Ms. Fox Hodge, who has appeared before Your Honor in the past. She's unfortunately not available to be here today, so they're here with me instead. Now, I understand Mr. Bagwell had spoken with her in that December 2024 timeframe, introduced himself, provide heads up that they did intend to issue some discovery dispute letters, but then also to raise potential settlement discussions and mediation. So I'm the one who then responded to Mr. Bagwell early January 2025, just over a year ago, commencing those settlement discussions and conveying, as Your Honor may remember, our understanding that discovery efforts would be on hold until those discussions played out. Plaintiffs then filed a motion to compel. At that time, we hadn't had any meet and confer related discussions. They'd also filed a motion for a more definite statement that was withdrawn. And the following week, Mr. Bagwell then clarified by email that the Simmons wished to move forward in parallel discovery mediation, which is their prerogative. So when Your Honor heard parties' arguments, said, you know what, they're entitled to discovery, please make your production within 20 days of the order. That order was issued on April 8th of 2025. Plaintiffs had moved to alter or amend that order, again, similarly today, under Rule 37.014 to get attorney's fees awarded. But this court confirmed in its July 24th of 2025 order that awarding plaintiffs their fees would be unjust under those circumstances. So that's bringing us to document discovery that then unfolded. So defendants, my clients, did comply with the court's April 8th order, making our substantially complete document production, which we did believe was completed at the time, on April 28th of 2025. That's referenced in Exhibit 1 in the many exhibits we did submit, and forgive us, Your Honor, for all the paper, but we wanted to make sure that you had everything at your fingertips that you might be curious about. Now, meanwhile, we issued our own discovery requests April 15th of 2025. Plaintiffs responded to those on June 12th and 13th, I believe, and that was after seeking an extension reportedly due to an emergency health matter, which defendants agreed to without hesitation. We understand these things come up, and that can be reflected in Exhibits 3 and 4 to my declaration. In July, so the next month, we raised several issues with plaintiffs' June production, including there were several referenced attachments and emails that were missing and hadn't been produced, among a couple other issues. And plaintiffs did eventually address these deficiencies through their own supplemental productions. Those were made August 20th, October 15th, and then most recently, January 22nd. Now, back to our production, it wasn't until August 27th, so almost 4 months after our production, that plaintiffs did raise issues about that production by their letter. That letter is Exhibit 8 to my declaration that we submitted. We responded by letter. The parties held a meet and confer. That was on October 31st. And I believe Exhibits 16 and 17 have some back and forth after that meet and confer. We then made a supplemental production on November 26th to address some of the concerns. And then December 15th, leading up to this motion, plaintiffs issued another letter raising some additional discovery issues. And that was Exhibit 24, Your Honor. So in the cover email, and I think also on page 6 of that letter, opposing counsel offered dates in January to meet and confer. And we responded by a letter officially on January 12th of 2026. That meet and confer did take place by video conference on January 22nd. You'll see that acknowledged in Exhibit 33. And we did make a supplemental production on February 10th. This production had been discussed on January 22nd. This is where getting into the text messages that, Your Honor, I'm sure I don't need to tell you, production of text messages is a difficult thing to do in that it's hard to produce a native user experience, right? So what we had done in the outset in that April 28th production was, and as recommended by our ESI team, to basically turn on a screen recording when scrolling through the relevant text messages. So with the technology that we have in courtrooms today, you can go through and see, and it's a near native user experience.
If the plaintiff wanted to use any of those text messages, how would he go about doing that if there's no hard copy of that document? In other words, he has a screenshot or a video of text messages being rolled through. If he wants to highlight a specific one, how do you propose that he would be able to do that?
Yes, Your Honor. And I'll also note that we have produced PDFs, but to answer Your Honor's question, what we have done when we've received information in a video like that is we will take our own snip or screen cap of that video, which you can do when the video is paused, put it in a Word doc. You can OCR it pretty quickly in a PDF, and then you can bait stamp that and use it. Which
now you're with Baker Donaldson, is that right?
Yes, Your Honor.
How many attorneys do you have in your firm?
Firm-wide, it's I believe about 700.
700.
Yeah.
Mr. Bagwell, how many attorneys are in your firm?
It's just me. I've been using an ESI vendor, friend of mine from law.
The point of what I'm trying to point out is the experience that you may have with a 700-person firm is not going to be the same experience that a private practitioner would have who is a solo practitioner. And that's why I'm just highlighting that what might be easy for your firm is not necessarily easy for Mr. Bagwell's firm. And not to say it was wrong for you to have done it, I'm just simply pointing out that as a practical matter, his ability to utilize some of those procedures might be a little different than yours. But go ahead, I'm sorry.
Don't be sorry at all, Your Honor. Thank you for your question. And understanding that point, I also want to highlight that this case is thankfully not one of Mr. Bagwell's firm against my firm, but it's one of our clients against each other. And my client, Sunday's Pool and Spa, and Ms. Corey, it's a true small business, a true blue collar business. And there are different services that can.
I'm sorry.
Objection relevance.
Overruled. Go ahead.
Different services that clients can choose to invest in. And for a case that, when you're looking at discovery, and I'll skip ahead my outline a moment, the authority in State XRL Flowers versus Tennessee Trucking, which is cited in our brief, discovery should be appropriately tailored to the needs of the case, and that includes the parties' relative resources and the amount in controversy. And it is appropriate to limit discovery to the less burdensome means. And in that case, the Court of Appeals does note that it's a far greater cost in complying with a discovery request than making the discovery request. So back to the text messages, though. We did receive Mr. Bagwell's August 27th letter, and that was addressed in the meet and confer, and we did agree to the PDF format production. Now, when my client went through and used the technology that takes these the text message history and generates, I'll call it a scroll of, every single message sent to and from those two users, generated these new PDFs that are text searchable. And then from there, we had to then, as we would with an email production, apply the search terms, identify the responsive messages. We then look to the discussions immediately preceding and then coming after those responsive messages themselves to make sure that we were including the relevant context. And then for the exchanges that were, I'll say, wholly relevant. So I'll take a step back. We agreed to produce documents and high level here that related to the Simmons, the plaintiffs, that related to their pool, and that related to biodesign generally. And this is something we've put in our responses and objections back in October of 2024. This was explained in multiple letters and correspondence and at each meet and confer. And so, for example, the exchanges that were with individuals in biodesign, those were included in their entirety. For those that were with, for example, the contractors she would work with, there were relevant discussions that related to the Simmons and or their pool, and those were included in the production. And for the messages that were withheld from production, those weren't in one of those relevant responsive categories. So now, when that supplemental production was made on November 26th, it did become apparent, and Mr. Bagwell pointed out that there were, what I imagine happened is that if you sent a video back and forth or sent a text message, unfortunately, that file didn't load, so it wasn't visible after it was converted into the PDF. So what we agreed to do, and what we did do, is we had our client go back and pull each of those original native files, the photo and the video. And he had raised this formally in that December 15th letter, and we responded January 12th formally saying, yes, as we mentioned by email before, we're in this process. I think it was 56 or 57 different files that had to be identified. And not only did we pull them and produce them, but we made sure it was in a reasonably usable format. And we had a PDF version that was bait stamped for ease of use, but then we also made sure to include those native files so that you could see, okay, if it said image 3359 in that original PDF, you could match it up to, okay, this is image 3359. And when we spoke on January 22nd, this video conference meet and confer, I tried to explain this process to Mr. Bagwell, and I told him we expected it to be ready within the week. Now, for context, and we are not blaming anything on Winter Storm Firm, but it is important to understand the context here when you're talking about good faith and meaningful good faith efforts. That video conference ended, and about that time is when Governor Lee issued the state of emergency. That next evening is when Winter Storm Fern rolled in, and Mr. Bagwell had sent a follow-up email that had additional authority we had been asking him for so that we could evaluate his arguments, discuss it with our client, get back to him. And I was glad to receive that and was looking forward to addressing it. But I did respond almost, I think maybe 30 minutes later, as meanwhile, we're running around like chickens with our heads cut off. Is there salt? Are there shovels? Everything else, to say, look, received, and just want to let you know to be prepared, because he had set a unilateral deadline of, if we don't get X, Y, Z, our demands met by, I think, 3 business days later, it was Wednesday, January 28th, we're going to file a motion. I said, look, state of emergency, storm coming in. We don't know what's going to happen, but to the extent there are outages and or school closures, we may not be able to meet that deadline realistically. He responded the next day, the Saturday, as the storm was hitting us, to say, that is unreasonable and you're going to have to give us evidence of any outages or closures, which, when he said his clients had a need to push a discovery response deadline by a month for an emergent need, we don't ask for medical evidence. We don't ask, that's not what we do in this bar. We trust each other and we do act in good faith. And so, unfortunately, though, the next morning, indeed, Middle Tennessee was hard. I have a 1-year-old who's going to be 2, very unindependent. You can't take your eye off him or he is in something, right? I also have a 2nd grader, and the daycare and the school, they follow MNPS closures. So between that Monday, the 26th of January, I think it was, and Tuesday, February 3rd, productivity was difficult. And I explained this to Mr. Bagwell, and I asked him to have grace and compassion during that time. And he did not respond to that email, but instead he filed this motion. So, which
I would also like to object to this mischaracterization that I was rushing to file some motion. The truth is, we wanted to make sure that what we filed was filed in time to have a hearing today, so that there's no further delay denied offense. This is stretched out for over a year. And the things that we were asking them for were already PDFs in their possession that would have been easy and quick for them to turn around. And I'll save the rest for my reply, but I just want the objection to record of these mischaracterizations. This is pretty heavy spin.
Well, if it helps either one of you, I'm familiar with the ice storm that occurred in Middle Tennessee, because we were on the 2nd day of a rape trial in Dixon County, and the jury had just, the state had just rested, the defense had just rested. Both sides requested Friday evening around 6 o'clock or so to let the jury go home and come back Monday. 10 days later, the jury came back to decide that case. So we couldn't get anything done for 10 days due to the road conditions in Dixon County. Anyway, I understand the problems that were inherent in that, but I'll be glad to hear both sides of this scenario. So go ahead.
Thank you, Your Honor. At this time, I do want to turn to plaintiff's motion themselves and the motion itself. And plaintiff's motion seeks to compel 5 categories of information, and this is on page 2 of their motion. First, they address the insurance policy, and as mentioned earlier, that policy is not at issue or discoverable. And that December 15th letter from Mr. Bagwell, I believe, is where he states that the substance does not relate to the claims or defenses. We've already discussed Tennessee Supreme Court's decision, Thomas v. Oldfield, several times. That's a 2009 case.
How do you, excuse me for interrupting, how do you respond to Mr. Bagwell's argument that the relevance of the insurance policy is that your contract provides a specific provision that your clients were improperly insured?
Well, I will note that there is a provision stating that my client has all applicable licenses and insurance necessary to perform their services. I will also state that if you look at plaintiff's complaint, there is no allegation that my client was uninsured or underinsured.
That's just not true. It's right here. I can read it to you. It's paragraph number 14 of our complaint.
I'm going to let her make her argument, Mr. Bagwell, and if there's a legal basis for your objection, you need to state what the legal basis for, rather than just interrupt her to contest what she's saying. So you'll have your opportunity, but let's let her finish her argument. If there is an objection to be made, then you can certainly state your objection and the legal basis for your objection, but just simply standing up and saying that's not true, that's what your final argument will be for. Go ahead.
Thank you, Your Honor. In front of me, I have plaintiff's complaint. On page 6 is the fraudulent misrepresentation cause of action. Paragraph 32 there says defendants made false statements of material fact, which of course we deny, but reading from these allegations says of material fact to plaintiffs as described in paragraphs 8, 9, 12, and 14. So turning over to paragraph 8, it does not state anything about insurance coverage. Paragraph 9, saying that there are text messages relating to orders and biodesign, does not mention insurance coverage. Paragraph 12 does not mention insurance coverage. Paragraph 14 does not state insurance coverage. In fact, it doesn't meet the requirements of Rule 9 because it just says generally that defendants made quote unquote numerous misrepresentations regarding Sundays' capabilities, relationship with biodesign, and the specifications of the pool to be constructed. And I'm happy to walk this up and show it to Your Honor if you would care to review.
Not necessary.
And that addresses Mr. Bagwell's argument as to trying to claim that there is a relevant allegation in the complaint, which there is not. Now, he also mentioned that there was a text message sent by my client to a neighbor of the Simmons, in fact, where they're discussing the Simmons. And what she does state in a relevant part, and this is on page 25 of our brief, we took that snip and placed it in the brief. And what she says is, quote, they're basically banking on my insurance company to give them $400,000 and it's not happening. That's the reference to the insurance policy. So what she disclosed was the fact that she has a policy. And she disclosed her suspicion of what was in plaintiff's minds, which I will admit is speculation. That is not a waiver, and that does not put the content of the policy itself at issue here. Now, in plaintiff's other discussions and briefing, they rely on rules of discovery and evidence and some cases interpreting those rules that find exception to this default rule in the state of Tennessee that insurance policies are not discoverable. Those exceptions do not apply here. The fact that Ms. Corey sent that text message does not put the substance of the policy at issue. So we're not using it as a sword or a shield. During confidential settlement discussions, plaintiff's counsel had questions, and I did my best in good faith to answer them. And now it is being, I dare say, abused in an attempt to try and pull that into production. But to be clear, in any reference in plaintiff's pleadings, when they say anything was produced, there was no production of the insurance policy, nor do defendants intend to use it as evidence. Now, if it was something that was produced in an issue, then yes, production should follow the rules, but this is not one of them where we have a sword and shield issue. And also, I do want to reiterate that in order for something to be a waiver, it has to be clear and knowing. And again, that text message by my client does not.
What detriment to your client? Let's say that I find that Mr. Bagwell's argument that there should be a production of the insurance policy. How does that work to your client's detriment that a copy of their policy has to be provided?
To be frank, Your Honor, I don't think there's a clear detriment aside from just the forced error, if you will, that I believe that there's a reason that insurance policies shouldn't be produced. And my understanding, not that I was, a member of the Tennessee Supreme Court at the time, but it does lend to abuse by some in the plaintiff's bar to say, oh, you have $1 million policy, let's waive it in front of the jury, and then you get higher awards than should be. And that's not what we should be doing here. We should be sticking to the facts and the actual damages suffered, if any.
Okay.
So again, as stated before, we do respectfully move to strike from the record any today, as well as any written references to any confidential 408 discussions, because it is only in connection with those discussions that any substance of the policy was discussed. I now have it in my outline to address the text messages, and we discussed those a little bit already. But again, it is my understanding that that February 10th production does address Mr. Bagwell's requests here. And again, this solution was offered formally in our January 12th, 2026 discovery dispute letter, and was explained during that meet and confer when I informed him of this tedious process that we were going through, to not just dump him with videos and pictures, but to give it to him in a usable format. I had said that day during our meet and confer that I expected it to take another week or so. And as Your Honor pointed out, things in Middle Tennessee kind of shut down for about 10 days at that time. And so there was about a 10-day delay from my initial estimate of when we get it to him. But in this, you can look at Exhibit 33 for this. When I did finally get a chance to sit down and meaningfully review his January 23rd email, I responded on February 6th. It was a couple days after we received notice of his email, but I don't like leaving loose ends out there. So I sent it just so that we could have made that response. And I did give the update saying, we'll get it to you by Tuesday, and we did. Now, to the extent that plaintiffs are seeking any further data or information, there were references to metadata and ESI in connection to these supplemental productions that addressed the video concerns that plaintiffs had. It is worth noting that plaintiffs also produced text messages through the same process of generating the PDF and sending it over. So to the extent metadata was included, it's just the metadata of when that PDF was created, right? You can see originally when those text messages were sent back and forth, the original dates, but that's just a date listed on a PDF. It's not metadata. Today is the first time I'm hearing about wanting to have my client, again, a very small business with limited resources, who is paying through this through any profit she gets, to hire a third-party vendor, which our firm does have agreements with these vendors, but they are extremely expensive. And if the rules do require that simply that materials be reasonably usable. We've now produced it in the format that Mr. Bagwell requested. And to the extent that he now wants a third effort, we do think that cost shifting would be appropriate here. However, given the scope of this issue and the needs of the case, we're not currently aware of any need for reproductions. I will acknowledge that Mr. Bagwell has now made accusations of spoliation. And first of all, this was raised in reply on the first time. We haven't had a chance to brief this. So to the extent Your Honor would like to hear briefing on that issue, we would like to have the opportunity to do so. I will note, Mr. Bagwell acknowledged that the text messages we did produce, which I will say were complete as they were presented to us as to the discussions with Biodesign, because again, Biodesign generally, those started, as he stated, and what was in my client's possession, May 11th of 2024. That was several months before they filed their complaint. So, and we walking around here today don't have an obligation to preserve information before that. Now, I haven't had a chance to talk to my client about it, but she could have gotten a new cell phone. So many things could have happened prior to May 11th of 2024 that would have caused that prior discussion to be something that someone from Biodesign happened to still have on hand that she happened to not have on hand. But I can assure Your Honor that the explanation is not nefarious and there is no spoliation. So moving on to the third category of information that Mr. Bagwell raised in his brief, although not here today. He requested a confirmation of custodians and data sources searched. That argument came as a surprise since I had already confirmed both by email and during our meet and confer the scope of our review. The custodians he lists in his briefing are third parties, not any Sunday's custodians, if you will. But also during that meet and confer, I offered and said, look, we could put together an ESI protocol, which would state plainly what was searched, which custodians, and what was available and everything else. I did point out that that would be a two-way street, and it was then settled, and Mr. Bagwell suggested that we move forward on good faith. So that's where I understood the issue had been left. Now, if here his clients had changed their minds, and we're happy to revisit the idea of an ESI protocol, but Mr. Bagwell did not need to file his motion to continue that discussion. The fourth issue raised on page 2 of their motion raises that a proper redaction and privilege log is needed. Now, what Mr. Bagwell is seeking is a log of the irrelevant and unresponsive communications that were withheld from the production, which is not required. So stepping back to that process where my client had used the program that generated, I'll say, the ream of one text message after another, going back for the full history, it would be as if, Ms. Moss and I email many times on many issues. And if there were a program that took all of our emails and just put it all beginning to end and not starting on a new page for a new message or anything else, just boom, 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 right after the other, let's say, well, if we weren't attorneys and privilege wasn't an issue, that, emails relating to just one case needed to be identified, it's possible that irrelevant information would be one from the other. Now, if this were a document that had existed prior to their discovery requests and was, used in the course of business or something else, that would be different. But this is a file that was created simply in the process of responding to their document request. And that in and of itself is not responsive. We used it to generate a text searchable format that could be producing the relevant text messages. Now, if we had gone the route of using this ESI vendor, it would have only pulled up one message at a time. And we would have then, just like we did for this one, pulled the immediately preceding messages, the immediately, after the fact to give context to the responsive and relevant ones. And so what plaintiffs have received is the scope of relevant and responsive information. Now, how the rest were withheld should not matter. And the fact that there are relevant and unresponsive messages that were withheld is not news. And the rules do not require that a log be presented, because we would be here forever, right? The scope of information out there that's not responsive is large and significant. And I would not expect opposing counsel to do the same, to have his clients go through and say, well, what emails do you have in your inbox that you did not produce? That's not what the rules require. That process, if you're curious, was also detailed on pages 29 to 31 of our brief. And I think that addresses that argument. Now, moving on, the final category raised in plaintiff's motion to compel is this stipulated protective order that would allow plaintiffs to seek confidential materials from the Board for Licensing Contractors, or the BLC. Now, plaintiffs had stated previously that they sought this protective order so they could confirm defendants' license scope and status, but as we raised in our recent correspondence, I think including on February 6th, that email I sent, that's Exhibit 33, my close up the loose ends email, I'll call it. We pointed out it's publicly available. Now, prior to the parties meet and confer, the justification that Mr. Bagwell had provided for seeking those documents was a statement of, quote, I have doubts regarding the bond and licensure from Sundays and Allison Corey. Now, a case that is cited in plaintiff's brief, the Johnson v. Nissan North America case, actually found that such suspicions are insufficient to render information discoverable. And as we already discussed, the complaint does not, in fact, allege that there was any, licensing issue or under insurance or anything of, for that matter. Now, in plaintiff's reply brief is where they're now newly stating that what they're really seeking and need the protective order for are for defendants' confidential financial and other records that end up getting submitted in order for the BLC to undertake its licensing processes. Now, this issue gave me flashbacks to October because it was in that, I think, August 27th letter and then the following discussions in that October 31st meet and confer, where Mr. Bagwell had requested information regarding all of the defendant's finances. And we again reiterated that, well, we believe that's outside the scope of discovery. We agreed to produce information relating to the Simmons, relating to their pool, and relating to biodesign generally. And so we took the position that that was not, relevant or necessary to the needs of the case. That was reiterated in a November 4th, 2025 email following that meet and confer. And then we didn't hear anything about that again until this reply brief. Now, again, I want to reiterate that Flowers v. Tennessee trucking case, that really, the scope of discovery really should be tailored to the needs of the case. And we believe that defendants have met that burden of producing the documents that are reasonably necessary for this case to move forward. Plaintiffs then seek what they call sanctions, then attorney's fees pursuant to Rule 37.01, paragraph 4. As set forth in great detail in our response, neither sanctions against defendants nor attorney's fees in plaintiff's favor would be appropriate under these circumstances. Defendants have fully complied with your April 8th order. Our production was made as ordered on April 28th. Plaintiffs, for their part, did not issue their first discovery dispute letter until August 27th, which was responded to and addressed. Now, both parties have engaged in the usual discovery deficiency correspondence and follow-up and supplemental productions. Again, we made our initial production April 28th. Questions were raised at the end of August. We had a meet and confer supplemental production on November 26th. Similarly, letter December 15th, meet and confer January 22nd, and supplemental production February 10th, as discussed and agreed. Plaintiffs, meanwhile, made their initial production mid-June of last year and made their own supplemental productions addressing our issues that we raised. Their productions were August 20th, October 15th, and January 22nd. Now, thankfully for all parties, and dare I say for the entire bar, failure to get it right and make a perfect production the first time out the gate does not warrant sanctions. And without any other evidence supporting Mr. Bagwell's claims here today that there's been some obfuscation or obstruction or good faith, we do respectfully submit that the court declined to issue those sanctions or fees. I'll also add that plaintiff's fee request fails to account for this 10-day delay necessitated by the ice storm, which did essentially close down Middle Tennessee. And I already mentioned, referenced my own personal experience that I was dealing with in the time that, schools and daycare were closed and not meaningfully being able to return to work until Tuesday, February 3rd, which I had very clearly advised Mr. Bagwell of, and again, I asked for understanding, but instead he did not respond, but filed this motion the day that really we were meaningfully able to return to the office, and I was, not having two very wild and darling children underfoot. Now, again, we think, especially under these circumstances, that both substantively, as we've already stated, but also procedurally, that defendant's position has been justified, and plaintiffs are not entitled to an award of attorney's fees. But also, and I do hesitate to harp on this too much, but if any fees or sanctions would be appropriate, we do think it would be in favor of defendants and against plaintiffs, because this is now the second time that plaintiffs have failed to meaningfully meet and confer in good faith and to allow that process to play out before filing a motion to compel. Throughout that January 22nd, 26th, it was this year, video conference, it was a difficult one, and plaintiff's counsel was not open to working with us, but instead, in his own words, admitted to being quote unquote extremely condescending, and even admitted that his behavior was quote unprofessional.
That's a mischaracterization of what I said, and also it's highly prejudicial and discriminatory. I have a condition. I have autism spectrum disorder. I admitted to opposing counsel that at the time of the meet and confer, I was in a state of autistic dysregulation. I told her that I wasn't showing up as my best self, and I apologize if some of my communication seemed unprofessional. And she's taking that and twisting that and using that in a petty way here to try to make me look bad for the court. But it is absolutely irrelevant to any of this and immaterial. It's just slanderous, that's all. So I strenuously object to this. That's
Noted your objection. I think that this is being offered, if I understand correctly, to show the good faith efforts of both sides. So we'll rule your objection.
Yes, Your Honor, and I will note,
Let me say this. I am not attributing it to prejudice either side, but rather to determine what the circumstances were regarding any pretrial or pre-motion efforts to try to resolve discovery disputes.
Thank you, Your Honor. And I will say that when Mr. Bagwell did disclose that, I offered to end the meet and confer right then and there and reschedule for a time that would be better for him. I'm very understanding. I have very, very close relatives in my household who do deal with atypical disorders. So I am understanding. The week before, when we were supposed to have the meet and confer, I had the flu. I had to reschedule. Sometimes you just need to reschedule based on health needs. And yet my client deserves to have a fair opportunity to meaningfully work out discovery issues before being brought to court to respond to a motion to compel. And it's for that reason that I'm bringing this up here today on my client's behalf. I had, during that call, made several good faith efforts, and Ms. Moss was on that call and she can attest to it as well, that were rebuffed. I was trying to get a sense of what plaintiff's support was for some of their positions, and I was accused of trying to act like the judge when really I was trying to get a sense of what the basis was so that I could review it and meaningfully address it with my client. Some of that was then produced to us the next day in that close of business January 23rd email. But again, that was almost exactly as storm firm came through, and I was not able to respond until February 6th, which I did, and which is included in our materials. Also, when I sought to explain defendant's positions, for example, with how we responded with the text message situation, the response was, "I don't believe that," or "I don't care what you have to say." And, in trying to get to some meaningful progress, there were even comments along with, "I'm fed up and we're done." And so then after that, when we did get the additional information, instead of allowing us a meaningful time to review and consider that new information under the circumstances, and this was days later, plaintiffs chose not to allow us some time, given the circumstances with the storm and everything else, to address any additional information and arguments, but instead filed this motion the very day, Tuesday, February 3rd, when the weather was finally over freezing for more than 24 hours and things were allowed to melt a little bit. So, again, if any party is entitled to attorney's fees, we do think it should be defendants, because we were not allowed a meaningful opportunity to address any of these further arguments until our briefing in here today. Now,
you think if you had an opportunity to address those arguments, that would have solved the problem?
Well, I think,
You want my opinion about that? I don't think it would have done any good, so.
perhaps not, but we could have at least tried, and I think we could have met the standards set by the rules that do require a good faith meet and confer. We do in response seek a protective order and a court-ordered mediation. As we've stated here today, we have more than complied with plaintiff's discovery requests to date, and to the extent that any further requests are made, seeking a third production in different formats and now new information that's newly being requested of us, we believe that defendant's production satisfies the requirements and especially in light of the scope and the needs of discovery in this case. Now, as Mr. Bagwell noted, parties have agreed from the beginning that this case is ripe for mediation, and yet plaintiffs have declined to agree at this time. We do believe that we're coming to the close of discovery, and we do respectfully request, document discovery, may I say, and clarify that it would be a good time to mediate in good faith, and it is within the court's discretion to order that, and it would be in the interest of judicial efficiency. Now, plaintiffs do raise new arguments that we think are not ripe for consideration at this time. The Tennessee Court of Appeals in Gentry v. former Speaker of the House, Glenn Cassida, that's dated September 17th of 2020, is very clear, quote, "A reply brief cannot be used to raise new issues." Now, to the extent that the court wishes to address them, we again reiterate a request to have that put forth fully before the court with a motion and a response and opportunity to be heard, because this is something that came as news to us through the reply brief. And again, to be clear, defendants firmly deny that any spoliation or curation or any of that has taken place. Again, counsel's desire to have the motion heard today does not excuse any failure to meet the requirement that he first meaningfully meet and confer in good faith. When he issued the December 15th, 2025 discovery letter, and that cover note offered dates in January 5th, 6th, and 15th. And again, my schedule is largely dictated by MNPS's schedule. So school didn't go back until January 6th this year. So January 15th was the date we'd agreed to. I had to reschedule because I did come down with the flu, not a 24-hour one. Unfortunately, it lasted a bit longer than that. And opposing counsel did reschedule to January 22nd. And it was only on January 22nd that Mr. Bagwell mentioned that he wanted to have this motion heard today. Now, why, I'm not sure, because there was no deadline for the filing, no other rule compelling Mr. Bagwell to file a motion in order to be heard today. So I think that any kind of timing pressure was of plaintiff's own making.
Could be because we rotate in and out every month. There'll be a new judge here next month. This is our circuit civil docket call for the month of March. So if it weren't heard today, I would assume Mr. Bagwell understood that it would be probably 4 months down the road before it could be heard. So
Understood.
I would assume that's why the pressure was on.
Okay. Again, we weren't informed of that until January 22nd. But we would also submit that mediation is not premature here. At this point, plaintiffs claim that materials haven't been produced that would be necessary, but those documents at this point either don't exist, are not relevant, or are otherwise not discoverable. So any postponement on that basis would not be justified. And now, for the first time, opposing counsel's bringing up that they may plan to amend their complaint. Now, I'll note they have not yet filed such a motion. But then if it's true that it would be premature to mediate, then I would respectfully request that we stay proceedings in the interim, because if an amendment would potentially move the ground to that extent, then perhaps we should wait until we have a governing amended complaint before moving forward.
All right.
Thank you.
Okay.
there's a lot of doublespeak and misdirection and obfuscation to have to keep up with and all of that. But let me try to clarify a little bit. And first, I'd like to just state a couple of things in reply for the
For you
record.
to keep up with it?
Yes, Your
I
Honor.
would have said in my seat.
I,
Both of you are living with this case, and we have two substantial volumes of file that have been produced in this ongoing case. And obviously, this is a case that I will again have to take under advisement in order to consider each of your allegations and each of their responses, which is not something I can do just listening to it, although I think you're both eloquent in your delivery of your arguments and passionate in your delivery of your arguments. It is still a case that I'm going to have to then review when I have more time to consider each and every objection that you have or shortcoming that you believe that they have had in their discovery responses and their response to that, so that I can determine under the rules and the applicable case law whether or not each one of those independently should be granted or denied. So
I understand. I have nothing but empathy and compassion for Your Honor's position and all of that. And with that in mind,
I'm not asking for you to feel sorry. I'm just asking you to understand that I'm necessarily going to have to take it under advisement.
sure, absolutely. To help ease that, I have a couple of thoughts that I'd like to offer in reply. First of all, I have nothing but compassion also for opposing counsel and all the many difficulties that she has repeatedly talked about having as a result of having to keep up with a parenting schedule. I'm a single parent raising a 7-year-old, 50% of the time with me, 50% of the time with his mom. During the time of the ice storm, he was with me. And Cheatham County schools were out of school for 10 days. He's over at Pleasant View Elementary. And so I get it, because I was also juggling work from home at the same time, and I was getting all of my work done, and I'm not part of a firm that has 700 lawyers. I don't have Miss Moss to help me out, or Claire Fox Hodge to help me out, or any of the other paralegals or secretaries or administrative assistants or support staff. I don't have an ESI division to help me out. So I just don't have all of those resources, and yet I managed to get things done. And at the end of the day, really all I was asking for was PDFs already in her possession, presumably in her email even, that she could have just emailed over. And the excuse given for not signing the stipulated protective order was, I don't have authorization for that. Just meaning her client said no. Also, there's so much disingenuous stuff that's being said here about their supposed good faith efforts to comply. All they had to do was plug an iPhone into a $40 piece of software and hit export, and then not refuse to give over the highly relevant messages that would have been in that thread, to just not exclude evidence that's in the thread. That's ultimately what they did with the PDF production to a certain extent, except that they withheld a lot of things. The video was not in a reasonably usable format. It's not just about the hyper technical metadata. It didn't even include things, basic things like date stamps a lot of the time. And it's virtually impossible to Bates number and cite in the record to messages that you're flipping through on a screen cap recording. The defendants claim that it would have been burdensome or difficult, or it wouldn't have been the proper thing to do as per their ESI staff's recommendation. It is ludicrous. You just plug it into a $40 piece of software and hit export for the whole exchange with Biodesign. And they're saying that, oh, we gave over everything that was relevant, everything that was responsive. But I would respectfully draw the court's attention to just if you'll indulge me, just one text message that they're saying is not responsive. This is specifically a message from Francis Leogrand at Biodesign, talking about my client's pool, this exact case, this exact situation in February 12th, 2024 at 10:40 a.m. This is an exhibit to the reply to the response to our motion. He says, I didn't speak to this homeowner, referring to my client, Thomas, speaking about Miss Thomas McClure, one of the people who I believe trained Allison Corey and her point of contact for purchases and that sort of thing from Biodesign. He said, I didn't speak to this homeowner, Thomas did. He stated that you, Allison, Miss Corey, defendant Corey, had not bought material from us in over a year and a half
not that you weren't an installer. Regardless, you've already said you've decided not to install BioDesign anymore. Plus, from my understanding, you and Thomas have had discussions about being retrained before you can purchase any more design material. And he goes on, I won't burden the court with further examples, but he just goes on to say, look, you've had so many problems and now your customers are coming to us seeking warranty protection under the warranty that it's become a problem for us. I've had numerous conversations with Russ Mabry, the current BioDesign installer who took up this area after Miss Corey stopped doing business with BioDesign, and he is exasperated with having to go and fix Miss Corey's mistakes to the extent that he's reluctant to even come out and give my clients an estimate, another independent estimate for what it would cost to fix all of this, because he's sick of going and cleaning up after her. There are extensive communications between her and BioDesign and other people, other third parties, between her and Narcissus Palomino, between her and Brian Wallace, that we believe are out there that she has in her possession and is refusing to give over, just like she refused to give over these messages that had to be in her possession, that were definitely related to a dispute that she knew was open and ongoing. So either she deleted them, therefore doesn't have them, or failed to retain them, or whatever. But in any case, or she has them and refused to give them over knowingly and willfully. In any case, it's spoliation or spoliation by curation. And opposing counsel, all they had to do was just read the entire thread. But what they're doing is, I believe, relying on just whatever their client gave over. In fact, Ms. Ray basically admitted that just now, just a moment ago. She said she had her client pull the files. But it seems her client didn't pull all of them, I guess, giving opposing counsel the benefit of the doubt. Surely she wouldn't see them and then withhold them. So giving her the benefit of the doubt, I'm just assuming that her client just didn't want to give over the ones that showed her incompetence and fraud. Defendant counsel's admission that they excluded some messages also proves my point. And they excluded some messages, but they're claiming, privilege or protection. And the advisory comment to Rule 26.02 says that a party asserting a claim of privilege or protection after production must give notice to the receiving party. That's the privlog. And the notice should be in writing, unless the circumstances preclude it. Here, that's not the case. Such circumstances could include the assertion of a claim during a deposition, again, not relevant here, but the notice should be as specific as possible in identifying the information and stating the basis for the claim of protection or privilege. They have not done that. I've asked for them to do it. They've refused to do it. As for their ESI protocol suggestion, I did have a discussion during the meet and confer, which I engaged in absolutely in good faith, despite my compromised state. I was there in good faith, doing my best. Perhaps my best wasn't good enough, and I asked for understanding about that. And Ms. Ray said she did understand. And so we had an understanding. I was there in good faith. Just because I was a bit out of sorts doesn't mean that I wasn't there trying to do my best. In fact, I remember from that meet and confer, at the beginning of it, we basically admitted to each other, we could probably recite each other's arguments. To Your Honor's own point, would it have done any good? It would not. Because at that point, we could recite each other's arguments. But opposing counsel, not only, in addition to the doublespeak, she engages in a lot of goalpost shifting. It's an endless delay, deny, defend requests to ask for, prove this, prove that, show us the basis for this and that. And I told Ms. Ray, I said, you can do your own legal research. I've given you everything I need to do. But in spite of that, I said, fine, I'll go and I'll give you more of the types of legal research that you're asking for. And I did submit that very, very promptly. They absolutely had a fair opportunity to discuss all the issues. But I asked her at the beginning of the meet and confer, I said, look, I don't want to be here for a whole long time wasting our clients' precious resources. I didn't want it to be an hour and a half long. I wanted to get on through it and say, let's discuss what we can agree about. What can we agree about? That was me in good faith asking her to participate. And the answer after an hour and a half was virtually nothing, except me giving some more concessions to her to go and do some legal research for her and send her some stuff that I did send her by email. Also, my suspicions that she cited in my correspondence about the BLC's relevance, that's not the only basis for that request. It's my understanding that there's an interplay, and I may be misstating this, but my understanding is that there's an interplay between the amount of bond that you have to carry with the Board for Licensing Contractors, or the amount of bonding that you have to have for your contractor's license, and the amount of insurance you carry. Ms. Corey has been dishonest about whether or not she has insurance that would cover my client's claims in this case. And that's been proven by the Rule 408, I guess, or the, the exclusions page that were offered up, right, for the insurance policy. Right. And Rule 408
Objection.
Rule 408 governs admissibility at trial, not discoverability. Under Arnold v. City of Chattanooga, they waived any protection by selectively weaponizing this document, bringing it in to try to lowball a settlement offer. It may not be admissible, but it is absolutely discoverable. It's hard to look at these disclosures from Biodesign and say that they're not relevant, because they're all talking about my client's case. And I mean, about her project, the pool. And they're all talking about the relationship that Ms. Corey has to Biodesign. And as opposing counsel just got up here and admitted that that would all be responsive to the discovery requests. And yet they didn't turn over all of that. And I suspect they have a lot more. The only way to get the entire evidentiary record that would actually prepare us for mediation is to do what we're asking for. And to put some real teeth into an order requiring them to comply with the order that they have never complied with from last year in the form of sanctions. Because unless they feel some consequences, they're going to continue the obfuscation, the doublespeak, the delay, deny, defend tactics, the dishonesty, the goalpost shifting, and the distraction. It's enough already. And that was the exasperation that I had in the meet and confer with Miss Ray. I said, look, it's been a year. You've had plenty of opportunity to comply. It's not about February 22nd or 10 days during an ice storm. They had ample opportunity for a year before to do what they know they have to do, and yet they just don't want to, because they don't want to show that Miss Corey at best was probably underinsured, and that I don't think that she's complied with all her licensing requirements. And I think the confidential records from the Board for Licensing Contractors would prove that. And if it wouldn't, then to your Honor's point during opposing counsel's response or rebuttal, what would it hurt to have the definitely discoverable, maybe not admissible insurance policy? What would it hurt to have under a stipulated protective order the confidential records from the Board for Licensing Contractors? In this case, more information brings us to a better decision. Hiding the ball on things to obstruct does not. That's not in anyone's, or it's not in the best interest of justice, although it may benefit Ms. Corey to hide the ball on some of these things. And as to our reply bringing up new issues, absolutely we are not bringing up any new substantive issues. The evidence that we've submitted simply shows that they have been withholding documents or that they've engaged in spoliation by curation. However you slice it, the reply does not bring up new legal issues. And a protective order trying to bar further discovery, it's just part of the pattern, isn't it? Please don't make us give up any more information. Please don't make us comply with any more discovery. Please don't look at our insurance policy. Please don't look at our Board for Licensing Contractor records, because none of that would go well for them. Even if there was something that Your Honor wanted to do to limit discovery, it would be to close discovery, not to impose a protective order, I would think. We don't even have a scheduling order in this case. And a lot of what I've been doing in this case has been based on the trust that opposing counsel mentioned we should have at the bar. And I would like to have been able to continue trusting her. But when it's clear that they're withholding information and we have to go and get it from a third party and we do in fact get additional information from third-party disclosures, it belies their claims of good faith in going through their client's records. At best, they're just taking whatever their client gives them and saying, good enough, but it's not, because their obligation goes further than that. With respect, that's all I have at this time. Thank you, Your Honor.
All right, as I indicated, I'm going to have to take this matter under advisement. I don't need to hear anything else. So I will take it under advisement. I will consider each of your allegations regarding the deficiency in discovery, and I will review the answers that have been provided by the defendants, and I will make a ruling as to each one.
Thank you, Your Honor. Are you excused?
Pardon?
Are you, right now, are we finished? May I be, I'm sorry, I didn't understand.
Let me say this. Here are your files.
Right.
So I'm not going to do this in the next few minutes. You're going to be excused until I get back with you sometime this year.
Thank you. That's,
and you might take that to your clients and let them know that when you come to me and ask me to have to resolve these disputes, it is not something that I can just simply flip a coin and say, yes, I'm going to do this or that. I'm going to have to analyze each one of your objections and then put a ruling down as to every piece of information that you're saying they didn't produce, why they're saying they didn't produce it, and what their response is. It is not, in my opinion, beneficial to your clients to expend that type of energy for you and having to come into court. But I'm willing to do it. It's just going to be time consuming. So I know you spent a lot of time on this, and I will have to spend a lot of time to do it. And nothing is going to be moving forward in your client's case until I make that resolution, which is not in your client's best interest either. So I wish you two could come to an agreement and resolve these matters, and mediation will be required. But as Mr. Bagwell has pointed out, if discovery is not being completed, then it is probably not a good idea to order mediation to be forced upon you when you haven't successfully completed your mediation. So I will try to get you an answer on these things as quickly as I can. I said sometime this year, but clearly I'm going to hopefully within the next few weeks or months get it to you.
Thank you, Your Honor.
Thank you very much, Rob. We will take your leave.
That's if we don't have another ice storm in the month of March. So what about this one that's the motion to strike the defenses? Is that one? Great. So this is the last. Okay, you want to call the case? Okay.
Yes, Your Honor, not this is correct.
I do believe we have the court interpreter.
Good morning. This, if we could come forward and bring everybody that's going to testify for us so that we can go ahead and have everybody placed in the room. All right. Let me just, normally in a criminal case, we would place you under oath as an interpreter, but I'm assuming this is not necessary for, do you have an oath? For, let's go ahead and have you sworn in as our interpreter so there's no question about it. So.
You solemnly swear that you will interpret accurately, communicate, and impartially, using your best skills and judgment in accordance with the standards prescribed by the law and the rules of ethics, so you can language interpreters that you will follow all official guidelines established by the court for legal interpreting or translating, and discharge all solemn duties and obligations of legal interpreting. I do.
All right. This is a minor settlement in which the petitioners Rebecca Santos Lopez and as the legal guardian of Edwin Vasquez and Gina Stallings and their attorneys are asking for approval of a minor settlement. I'll let you take it from there.
Yes, Your Honor. Hopefully this will be much simpler and quicker than the other cases you've heard this morning. This was a,
Just keep in mind you have an interpreter that has to
Yeah.
repeat everything you say.
please speak fast, so I will try to fight that urge. This was a minor accident that occurred at a stop sign. As a result of that accident, Edwin was taken to the ER just to make sure he was okay. He was okay and had just minor follow-up with his pediatrician. As a result of that, he had medical bills totaling $6,223.54. We were able to get a settlement for $12,000 in total. Out of that amount, we are asking for $4,773.90 in attorney's fees. There is $896.11 in expenses. The amount that would be paid into the court for Edwin is $4,774. And the remaining is to pay off subrogations related to that, those expenses. I did have a couple of questions for Rebecca, if you'd like to swear her in.
All right, Miss Rebecca, if you will raise your right hand and be placed under oath.
You solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth. Yes.
Thank you. You may put your hand down.
Are you Rebecca Santos Lopez? And you are the parent of Edwin Vasquez?
Yes.
And you understand the terms of the settlement I've presented to the court?
Yes.
And you understand that in exchange for the settlement money being paid by defendants, this will settle your child's case full and final? And you cannot bring any further claims?
Yes.
You understand you do not have to settle your case, and you have the right to go to trial if you do not wish to accept the settlement.
Yes.
Right. Do you agree this settlement is in the best interest of your child? And are you asking the court to approve it? I have no further questions, Your Honor.
All right, then I will approve the minor settlement. You have an order?
I don't know. I'm covering for, I have the joint petition. It doesn't look like I have the order, but we will get that in.
You may submit your order.
Yes, sir.
Thank you.
Thank you.
All right, that concludes our circuit civil docket call, so we'll shift gears to chancery. You're gonna leave us your computer. Maria, thank you for being here. All right, we'll start through the chancery docket if you'll call the first case.
in 484, and we said Sandra Elizabeth Kilgore.
In that case, Your Honor, I'm appearing on behalf of John Crow to get today. Ms. Kilgore passed away last December. She only had 3 heirs. We're just asking to establish the will from unum of title in that case. I brought with me an order.
All right. I will grant your request.
All right, thank you, sir.
You have an
May I
order?
pass up the order? Thank you. All right, thank you, sir. Thank you.
Thank you.
Thank you, Your Honor.
Deed 4183, he said Michael P. Miller.
May it please the court, I'm John Kitch of the Tennessee Bar, and I'm here on behalf of Mr. Nathan Palazzi. This is his wife. Both of them will be witnesses for a quick interrogation.
All right, if you'll both come forward, raise your right hand and let our clerk place you under oath.
I swear.
Your Honor, this case is, may I have them be seated while I
Yes.
present what we have. This is a petition of probate, the last will and holographic codicil of Michael Pink Miller, or in the alternative to open the intestate estate. You have the original will. The will itself does comply with the statute and has self-proving affidavits. But what makes this a little unusual is the fact that this gentleman wrote on his will and I think complies with the requirements of a holographic codicil. And if I might invite the court's attention to the will itself.
I'm looking at it.
Pardon?
I am looking at it.
All right, sir. On the front page, handwritten is, "This is what I want, 7/5/19," and then initialed MPM. And please accept these as the wishes. And there are a few other things that I would point out, and I will have these people testify that they are familiar with his handwriting and that this is his handwriting on this document. On page 4 of the last will, at the top, he changes the trustee of the trust. And I should point out that all of the residuary beneficiaries are adults at this point. However, this creates a trust that restricts the distribution of assets to them, subject to the trustee, which he has changed from Raymond James Trust Company to U.S. Bank. We have not yet inquired as to whether or not the bank will accept that responsibility, but that is something we will do once Your Honor has ruled on this matter. Moving over to page 8. Under executor nomination, Mark Miller was nominated first, and if he were unable or unwilling, then Ben Johnson was nominated to serve, and if he was unwilling, the decedent wrote in the name Nathan Palazzi, who is this gentleman here. We have submitted declinations to serve on both of those prior two people. And then the guardian nomination part on page 10 is irrelevant anymore because these children are all adults. That's basically our position, and I'm sure Your Honor would like to hear testimony from these two witnesses.
I think in order to consider the handwritten provisions as a codicil, we'll need to establish that the handwriting is of the decedents, as the statute would require. So if you want to bring your clients forward.
Thank you.
Witnesses forward.
And they are disinterested parties within the meaning of the law, Your Honor.
Okay.
They do not take under the document.
All right. If you'll
Please
come forward
state your
just a
name to
moment.
the court.
Lindsay Palazzi.
And how did you know the decedent?
He is my nephew's father.
All right, and have you taken a look at his handwriting on this document that purports to be his last will and testament?
Yes, I have.
Are you familiar with his handwriting over the course of time?
Yes, I am.
Do you believe this to be his handwriting on this document?
Yes, I do.
All right. Mr. Palazzi, how do you know this gentleman?
Mr. Miller was also my nephew's father, and he was a good friend of mine.
All right, and do you know his handwriting?
I do.
And have you reviewed this handwriting on this document?
I have.
Do you believe that to be the handwriting of Mr. Miller?
I do.
All right. Fiona, please, do you have any questions?
No, I don't. I think they have established that the handwritten provisions are the genuine handwriting of the decedent. Therefore, the court will consider those handwritten provisions to be a codicil to the original will. And both the original will with the self-proving affidavit and the codicil that is handwritten by the decedent will be admitted into probate.
Thank you, Your Honor. Now, we have no assets as of yet and don't know for sure what assets are coming in. So I have prepared a proposed order reserving bond inventory and accounting for a later time once we begin to acquire things. And we, of course, are asking that Mr. Palazzi be appointed as personal representative of the estate and reserve bond inventory and accountings to a later time.
All right.
And I will, as appropriate, move the court to set a bond. I am going to inquire of the beneficiaries as to whether or not they might waive these provisions, but I also have to talk to whoever is going to be managing the trust to see what their position would be.
That would be fine. Just submit the order that you have drafted if you wish. And
may I approach?
You may.
And then I guess Mr. Palazzi will go down the hall and sign the bond, or sign the oath.
Clerk can assist you with that. So I'm just going to leave blank the dates for the inventory and accounting because of the fact that we don't know if that's even going to be necessary. So
that's correct, sir.
All right. Thank you.
Thank you, sir.
We have somebody the pro se. Let's go ahead and take that one up. We have somebody coming in by Zoom that I'm going to take up as a pro se divorce. That's the last one. Mandy Lynn Totoro versus Michael Brett Sinclair. All right.
I'm here, Your Honor. You can hear me.
If you will raise your right hand and be placed under oath, please. All right, you are Mandy Lynn Totoro, is that correct?
Yeah.
Ms. Totoro, you filed a complaint for divorce using a form the state provides online for individuals wishing to represent themselves that contains certain statistical information. Is that information true and correct?
I'm sorry.
Is all of that information in your complaint true and correct?
Sir.
Also, you've filed, I think, a marital dissolution agreement, again, using that form that the state provides online. Is that your signature on that form?
Yes, sir.
Do you believe that form fairly and equitably divides all your property and distributes all of your debts?
Yes, sir.
All right. Mr. Sinclair, if that is you, if you will raise your right hand, let me place you under oath. Do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
We're not hearing you, but you can acknowledge by nodding. Apparently,
Yes,
there's
sir.
some problem with putting forward. Mr. Sinclair, is that your signature that appears on the marital dissolution agreement? You can put your hand down now, sir. And do you believe that agreement also is fairly and equitably divides all your property? The record will reflect that you have nodded in agreement with those factors. All right. Have you prepared a final decree of divorce? That would be the next form that would be necessary. So. And you're not changing your name, correct?
No, sir.
I'm going to ask you, Mr. Toro, if you will sign off, since you are here, that I just need you to fill in the date and your signature on that last page. So.
Thank you.
Yep.
I'm going to give you back your marriage certificate. This appears to be the original. You may want to keep it as a keepsake, or you may want to use it for target practice, whatever you choose to do. But as of today, it's not necessary for that to be provided through. All right, I will grant your divorce and sign off on your final decree. You can get a copy of it from the clerk's office a little later in the morning, okay?
Okay.
All right,
Thank you.
Thank you, Your Honor.
Mr. Sinclair is free to go. So. All right, you can call it. Okay, so I just want to get that person that was on Zoom now. We'll go back to the regular docket now. Good morning. You filed a petition for a name change. Is that correct?
Yes,
so raise your right hand. Let's place you under oath.
I do, yes.
You have filed a petition to change your name to Sabin Noir Heatherly. Is that correct?
Yes.
And I'm required by law to make sure that you are not changing your name to avoid criminal prosecution. Are you asking to change your name to avoid criminal prosecution?
No.
Are you asking to change your name to avoid your just debts or creditors?
No.
The reason you've listed in your petition, is that the reason that you want to change your name?
What was that again?
You have set forth a reason in your petition why you want to change your name. Is that the reason you want to change your name?
No.
All right. Why do you want to change your name?
I feel like my name, my name now as Peyton, doesn't constitute with who I am as a person now.
Okay.
Since I am a transgender woman, it kind of brings basis to like me being a boy, in my opinion, still.
All right. You have requested to change it to, is it Sabine?
It's Sabine. It's French.
Noir Heatherly. And have you prepared an order that grants that name change?
I have the paperwork at home, I believe.
Okay. You'll have to submit an order that actually changes your name, and it'll need to change it to the exact name that you have spelled out, and you sign off on it and submit it to the clerk.
Oh, yes, I did do that
with
Rhonda.
Pardon?
I did do that with Miss Rhonda Vaughn.
Okay, yes. And then I will sign off on it once I have that order, okay?
Perfect.
All right, thank you.
Thank you
I'll
so
grant
much.
your name change. Won't be effective till I sign that order and it gets filed with the court.
Awesome. Thank you, Your Honor.
All right, thank you. Call the next case. You hear civil cases now? Is that what you're doing, sir?
No.
Okay. All right.
Your Honor, he came to make sure I was doing my job, I suspect. He's always following me.
All right, you have a motion to deem service upon someone, is that correct?
Yes, Your Honor, we've tried to do personal service. It's been returned. He has been unsuccessful twice. He hasn't done a return because we were trying to keep finding her. She and I have had a Zoom. I've emailed these documents to her. We've had multiple conversations about this. And I've asked her repeatedly, how can I get these to you? How can I get these to you? And she will not respond. But like I said, I've emailed the documents. We've had a Zoom meeting to talk about a settlement, and then she just won't follow through.
Well, the purpose of service is to make sure that the defendant is aware of the pleading of the proceedings and has been given proper notice, clearly from what you set forth. this individual has notice of these proceedings and is attempting to avoid service, put an order down that the service is effective as of today, and she has 30 days to file a response
Thank
to
you.
your pleadings.
Thank you, Your Honor.
All right.
To show point more in was being on Friday, page and it's not.
In this emotional courtroom hearing, a judge approves a transgender woman's legal name change after she explains that her old name no longer reflects who she truly is. The hearing begins quietly after the judge finishes granting a divorce in another case before calling forward a young woman appearing on Zoom for a name change petition.
You filed a petition for a name change?
The judge carefully asks the legally required questions to confirm she is not trying to avoid criminal charges, debts, or creditors by changing her identity. Are you changing your name to avoid criminal prosecution? After she answers no, the judge asks why she wants the new name. That's when the atmosphere inside the courtroom suddenly becomes much more personal and emotional. The young woman explains that her current name no longer represents who she is after transitioning. I am a transgender woman. She quietly tells the court that hearing her old name still makes her feel connected to a version of herself she no longer identifies with. It brings basis to me being a boy still. The judge listens respectfully while confirming the exact spelling and pronunciation of the new French-inspired name she selected for herself. It's French. After reviewing the paperwork, the judge officially agrees to approve the name change once the final order is signed and filed with the clerk's office. I got your name changed. The woman immediately smiles and thanks the judge before the hearing moves on to other civil court matters involving failed legal service attempts and settlement discussions. What begins as a routine administrative hearing slowly turns into a meaningful courtroom moment of identity, transition, self-expression, and legally becoming the person someone truly feels they are inside. Do you think legal name change hearings can have a huge emotional impact on someone's life and identity? Like and subscribe for more real courtroom moments.